Alright guys, so the topic for today, this is a topic or something I've seen referred to me as a question on multiple occasions. And the question is, can you resist arrest if the police officer is illegally trying to arrest you? You know, we see this a lot across the country. And there's all these videos of people saying, I have not committed a crime, you cannot arrest me. And, you know, windows getting busted out, people resisting arrest. And then the comments will say something like, you know, that wasn't even crime. The officer shouldn't have been arrested him. You have the right to resist arrest in that situation, blah, blah, blah. Well, the answer to that question is no. No, you do not have the right to resist arrest, even if the police officer is arresting you illegally, or they don't have the legal grounds to arrest you, or they are arresting you based on a bad law. This is something that has been established across the entire United States, either by judicial precedent or through an actual statute. The way we're going to address this question today, though, is we're actually going to look at a case that was in the Ohio Supreme Court in 1975. And this is actually the City of Columbus versus Fraley. Now, hopefully you'll understand a little bit more about it when I'm going through. I chose this case simply because down towards the end, there's a paragraph that very succinctly kind of sums up the reason why the judges came to the decision that they did, and why this is basically now the law of the land across the United States. For this particular case, I can go down here. What they did on this one is they actually heard two cases at the same time. The first one is one that is, I don't know, it's a different case. And then the second one right down here, this is where we get into the City of Columbus versus Fraley. This is a situation where there was a law in the books in the City of Columbus regarding hostile speech. And it was under, I want to say, the disorderly conduct section of the Columbus City Code. Now, this was still part of the city code, even though there had been multiple cases across the United States that would make this null and void. Basically, the legal advisors for the Columbus Police Department in the 1970s, just as a long time ago, this is way before the internet, they were behind the times on updating the city code, and officers were using city code that had already been deemed unconstitutional, although they were not aware. So they went to arrest somebody for an unconstitutional law. The person resisted arrest. They charged him with disorderly conduct and resisting arrest. This case goes to all the way to the Supreme Court of the state of Ohio. The Supreme Court ruled that this law is not something that is enforceable, but they also ruled that the person that the officers were trying to arrest is still guilty of resisting arrest. So that's what we're going to get into here. So on November the 1st, 1971, Columbus police investigated two complaints by a white family in an interracial neighborhood. On the first occasion, two officers entered the area to investigate. On the second, they were joined by a police sergeant and two additional officers. So the first time, two officers arrived. The second time, 5 officers arrived. While the second complaint was being investigated, an argument broke out between the police and black residents of the neighborhood, one of whom, the appellate, Emogene Fraley. According to the testimony of police officials, the appellate became boisterous and loud, called the officers motherfuckers and pigs, and made statements that, I don't know what the asterisks are for, but it said made statements that if blacks had called the police, there wouldn't have gotten this much motherfucking police protection. When two officers attempted to place the appellate under arrest, she allegedly started swinging her arms, yelling, kick them, broke away, and ran across the street into her house. So the officers went to place her under arrest for her loud, boisterous swearing and language that was being used in the streets. She resisted arrest, ran into her house. They chased after her. They tackled her, put her in cuffs. They slated her for disorderly conduct and for resisting arrest. And it goes down in here, say that she was charged with disorderly conduct and yada, yada, yada. They said that the words that she was using were fighting words, and that is what has been established under the the judicial precedent as far as what is First Amendment and what is not First Amendment. You're not allowed to have fighting words. You're not allowed to elicit a violent response out of people. And the officers believed that the speech that she was using was intended to elicit a violent response from the officers. The court had already struck that down in multiple cases, and that's what happens when you go through these things. They'll go down through, and I'm not going to read all of the cases, but they're going to cite over and over and over again, people that were arrested for free speech. Like this guy was arrested for saying "fuck the draft." That was overturned. Roth v. United States, 1957. Something about a crudely defaced jacket. I don't remember what his speech was, but basically when you're going through these cases, they're going to say over and over and over again, here's a case we reference, here's a case we reference, here's a case we reference. And they go all the way through this and they say, listen, that speech was actually free speech. You cannot arrest her for that. So therefore the initial charge of disorderly conduct is going to be overturned, or the conviction for disorderly conduct is going to be overturned. But then they upheld the resisting arrest charge. And this is the part where I'm actually going to read for you a little bit. And this is actually the reason I chose this case in particular, because I like the way this is written. I think it is very common sense and very easy to understand. So to move my mic out of the way, because I'm reading from this screen here. And this is why they're going to say that you cannot resist arrest, even if you believe the officers are arresting you illegally. So it says an appropriate accommodation of society's interest in securing the right of the individual liberty, maintenance of law enforcement, and prevention of death or serious injury, not only of the participants in the arrest, but of innocent third persons, precludes the tolerance of any formulation which validates an arrestee's resistance of a police officer with force merely because the arrest is ultimately adjudged to be illegal. So there's the opening statement. They say, look, there's too much risk for bodily harm to the police officers, to the person that they're trying to arrest. And if firearms come into it, innocent third parties. You might be resisting arrest. You might legally be armed. If you draw your firearm and a police officer uses deadly force against you, they might hit, your kid that's standing behind you. They're saying that due to this danger, you should not be resisting arrest on scene. It's dangerous to the officers. It's dangerous to you. It's dangerous to your family. Don't do it. And then they go on to say force begets force, and an escalation into bloodshed is a frequent probability. The right or wrong of an arrest is often a matter of close debate, as to which even lawyers and judges may differ. This is probably my favorite line of the entire thing, and this is something that I'm going to start using every single time people accuse me or another police officer of not understanding the law. Because they have this person that's upset about something will have a certain interpretation, and they believe that their interpretation is the only interpretation. They are right, even though this has not yet been decided by the court. So I'll read that again. The right or wrong of an arrest is often the matter of close debate, as to which even lawyers and judges may differ. This is something that I like to remind people of, because you'll have an arrest, and the prosecutor's office, either the city prosecutor or the county prosecutor, will look at that arrest and say, you know what, that's a good arrest. That was good probable cause. We're going to take that to trial. Goes to trial. The person is found guilty. The person appeals to an appellate court. The appellate court upholds the initial conviction, and then that goes to the Supreme Court, and the Supreme Court actually will overturn it. That's a situation where you had a whole bunch of lawyers that believed, you know what, this is perfectly legal, this is perfectly constitutional, and then another group of lawyers in the form of Supreme Court justices will say, no, this was not legal, this is not justified, this is not constitutional, we're going to overturn it. Similarly, you have a local judge will dismiss evidence or make certain evidence not admissible because they don't believe that the officers followed the guidelines written in the Fourth Amendment of the Constitution. That will then, the city or county or the prosecutor will then appeal that to a local appeals court, and they will override what the local judge said. This is something that happens very frequently. So the court is saying, this is something that's very complicated that even lawyers and judges often argue about and are confused about the facts. We don't expect citizens and police officers to be able to make that determination, especially when the consequence is life or death. So what's the next one? It says, in this area, or in the era of constantly expanding legal protections of the rights of the accused in criminal proceedings, one determining himself illegally arrested can reasonably ask to submit peacefully or peaceably to arrest by a police officer and to take recourse in his legal remedies for regaining his liberty and defending the ensuing prosecution against him. That's just a continuation of the point. And they're saying, look, if you believe that you are being arrested illegal, that your rights are being violated, the best thing that you can do is surrender yourself peacefully, take it to court, and then sue the jurisdiction that is placing you under arrest illegally. And it says, at the same time, police officers attempting in good faith, although mistakenly, to perform their duties in effecting an arrest should be relieved of the threat of physical harm at the hands of the arrestee. Basically saying, if I'm out there as a police officer and I have all this training, I have years of training and decades of experience, I've been down this road many, 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 many times, and I go to arrest somebody, they have a responsibility to be arrested peacefully. Because if they start to resist arrest, then I begin to fear for my own health and safety. They're saying that a police officer who's doing his job, performing his duties to the best of his ability, the best of his knowledge, the best of his training, should not have to fear for his safety at the hands of an arrestee. Therefore, we should not be propagating the idea that you can legally resist arrest. And that was it for that. Yeah. So I'm going to go back to the beginning. This one, in my opinion, is a pretty simple one. And let's just rehash the facts for a quick second. So in this case, Columbus versus Fraley, Columbus police officers were responding to a call of some kind of neighbor dispute. During that investigation, one of the neighbors came outside, began yelling and screaming at the officers, accusing them of being racist and all that stuff. This is the kind of stuff that we still see today on a daily basis. The officers back then in 1971 believed that speech was illegal, that it was disorderly conduct because it was so loud, it was keeping the neighborhood awake, this, that, and the other thing. They went to place her under arrest. She resisted arrest by flailing alarms, kicking an officer, and then taking off running. She was charged with disorderly conduct as well as resisting arrest. This went all the way to the Supreme Court. The Supreme Court said the arrest was illegal, but her actions at the time of the arrest were also illegal. So this is a case where the initial charge was dismissed, but the resisting arrest was upheld. In today's world, this generally doesn't happen. We are trained, it's beaten into our skulls that you can't have a resisting charge if you don't have a good charge to begin with. And the way we handle things now is we generally don't write that charge in the first place. I'm trying to think if I've had any. Well, generally what we do is we go with obstructing official business. So if I'm on scene of some kind of dispute or something like that, and let's say one person is accusing another person of a crime, and I go to the accused party and I say, I need your name, date of birth, phone number, address, and all that stuff for my report, because this person wants to follow up with the courts and see if the court agrees to file charges on their behalf. the person who is accused is required to give me that information. If they don't give me that information, I can actually arrest them. Try not to go into like an arrestable situation, but let's just say rather than giving me that information, they take off running. So I have to chase after them, tackle them to the ground, put them in handcuffs, and then I have to determine who they are. Rather than charging them with resisting arrest, because I did not have an arrestable offense to begin with, I charged them with obstructing official business because I was conducting an investigation. I was trying to figure out who both parties were so that I could refer the victim to the court so that they could go after this person. That person is required to give me their information in that case. They took off. What they did is they obstructed my official business. So that's the charge that I would either issue them a citation for or take them to jail on. Usually if you run, I have to chase you, you're going to jail. But I don't know. That was kind of a long way of explaining how that works. At the end of the day, you do not have the right to resist arrest. The court has deemed that that safety is of the utmost importance. Safety of you, safety of the officer, and safety of innocent bystanders. That's the reason for this law. So if a police officer goes to arrest you for something that you know is against the law, your job is to peacefully be arrested and then fight it in court. I've repeated it enough times. Thanks for watching. I'll talk to you later.